I think now we should go ahead and get started. Looks like we have a lot of people joining and it's time to get this kicked off. Welcome back to the Volie Session, everyone. Very excited for today's show with you. We have a great guest lined up, a lot of good topics for you. Today we have our compliance lawyer on, Josh. Josh, how are you doing today?
I'm doing good,
Good. Definitely appreciate you taking the time. Josh Stevens is a partner at Mack, Murray & Schuster, where his practice focuses on helping highly regulated businesses understand and comply with federal and state consumer protection, marketing, telemarketing, and privacy and data security laws. As a former in-house counsel, Josh brings a critical client perspective to his work and has substantial experience representing clients across a range of proactive and responsive matters, including developing compliance programs, obtaining required licensing, responding to consumer complaints, and negotiating with regulators to bring concerns to resolution. We're very excited. We have a lot of compliance-based topics to share with you all today. And as always, this will be recorded today and will be available on our YouTube channel next week for you all. However, due to the nature of the topic, we won't be taking any live questions today, as Josh cannot give out legal advice over the webinar, but we will provide Josh's info. And if any of you have any questions, feel free to hit him up afterwards for anything, and definitely can help you out there. So with that said, Josh, let's talk TCPA and telephone compliance. You hear this term a lot, and people ask, the basic question, and I think it's fair. What is TCPA?
Yeah, and before we get into that, I'm just going to build on your disclaimer a little bit just to make sure we cover our ethical bases, that anything I say today is, of course, general education. It's not legal advice. And before acting on anything I say, those of you who are watching, you should definitely consult with your attorney, or, pick up the phone and maybe, hire me. But I just want to make sure we get that out of the way as we get going here. So the TCPA is the Telephone Consumer Protection Act, which is a federal law that was passed in 1991 that regulates telemarketing in the United States. And it's been amended a little bit over time and interpreted by the FCC and courts fairly significantly. But I think most people became aware of it kind of in the mid-teens, kind of around 2013 to 2015. Litigation around the TCPA really exploded. And it became actually the number one basis of lawsuits in federal courts, if you can believe that, for a few years. And I'll talk about in a second how that has trended down over time. But the point is, it's an important regulation if you're doing any type of telemarketing, or frankly, any type of telephone communications that involve automated telephone dialing systems or involve pre-recorded messages. The companion to the TCPA that I always like to make sure we don't gloss over is the Federal Trade Commission's telemarketing sales rule. The two are similar in a lot of ways, and probably won't talk as much about the TSR today, but the TSR is enforced by the Federal Trade Commission. It applies only to telemarketing. And so if you're not doing telemarketing, then you don't really have to worry about it. Unlike the TCPA, where, for example, if you use an automatic telephone dialing system, you may have some obligations, even if you're doing non-telemarketing calls.
Can you elaborate a little more, just to be as basic as we can here, for what is an auto dialer? What does fall into that group of things they're trying to regulate?
Yeah, so an automatic telephone dialing system under the TCPA, that's the fancy phrase for it. You'll hear me refer to it as an ATDS. In the world of TCPA, it's all acronyms, just fair warning. So an automatic telephone dialing system is a system that uses a random or sequential number generator to produce or store telephone numbers and dial them. Now, that definition has been the source of much controversy. And for a while, kind of starting around the mid 2010s, that definition was interpreted very broadly. Thankfully, in April of 2021, the Supreme Court, in what's in a decision, Facebook v. Duguid, which our firm actually co-authored an amicus brief on behalf of a trade organization in that case that was cited by the court in support of a narrower definition. The court said, you know what, no, we're not going to take this broad approach to what an ATDS is. We're going to narrow it. And we're going to say that it has to use that random or sequential number generator to produce or store telephone numbers. So if a system just dials from a pre-produced list, so think about like a typical predictive dialer, or a system like the Volie system, where the numbers are loaded in by the user and they are pre-selected, right? And then you are calling out on those numbers. You're not using a random or sequential number generator to create numbers. That's not going to be an ATDS. And thankfully, since the Supreme Court decision, lower courts have adhered to that view, with the exception of one court that tried to go a little astray. And certainly plaintiffs tried. I will give the plaintiffs bar credit. They tried to convince courts to go against what the Supreme Court said, but thankfully that decision has held.
Is there anything applicable there that would be similar for text messages? Does TCPA apply to text as well, or are we strictly talking telephone compliance?
Yeah, no, we're talking text as well. So the FCC and courts have interpreted the TCPA to apply to text messages. The other thing with text, and we won't talk a lot about this today unless you want to, but there are also guidelines that were created by the Cellular Telephone Industry Association that are not laws, but they are guidelines created by the wireless telephone companies that also regulate text messages. So we think about the laws that apply, but then texts get this extra layer of industry regulation that you always have to kind of keep in mind.
So not exactly, an auto dialer, but in the vein of telephone compliance, what is the federal do not contact list?
Yeah. So when I think of TCPA compliance, I like to think of it as having three main avenues. The first is the regulation of an auto dialer or an ATDS. The second is the regulation of pre-recorded messages. So I'm sure everybody listening has at one point or another gotten a auto warranty call, right? Those are pretty popular, and they're often pre-recorded, right? So you're not talking to a live human. Those are regulated under the TCPA. And then thirdly is do not call. So the Federal Trade Commission manages the National Do Not Call Registry. And so this is a list of numbers of consumers who have opted in to say, I do not want to receive telemarketing calls. And under the TCPA, you cannot make a telemarketing call to a number on that list unless you have one of two exceptions. The first exception is called prior express written consent. And that's a type of opt-in consent that meets very specific regulatory standards. The second, and what I would say is often more common, is what's called an established business relationship. And there are two flavors of that. So the first is called an inquiry established business relationship. And under federal law, that lasts for 90 days from the last time the consumer voluntarily inquired about your good or service. So if I call up a dealership and say, hey, I'm interested in this car, then that starts that 90-day clock. And they don't have, and so if my phone number is on the National Do Not Call Registry, which in real life it is, then they don't have to scrub me out on that basis for 90 days because I've made that inquiry. The second is called a transactional established business relationship. And under federal law, that lasts for 18 months from the last financial transaction. So using this scenario again, let's say I bring my car in for service, say I get an oil change, pay for that oil change. I've had a financial transaction. Now we can start that 18-month clock for the transactional EBR. And so again, you could make a telemarketing call under federal law to me without having to scrub me out of the list on the basis of my number appearing on the National Do Not Call Registry.
What are some of the best practices that you've seen to ensure that you are in compliance with this aspect of things? And keeping in mind that some states also have additional regulations with regards to this.
Yeah, so couple pieces. So at the federal level, you need to have a subscription. So it is not a free product. You have to buy a subscription to the list. The Federal Trade Commission allows you to do that online. And so all you have to do is go on ftc.gov. You'll get over to the telemarketer page and you can buy a subscription there. The first 5 area codes are free. They sell it on a per area code basis. And then every other area code, it's currently $69 per area code. Next year, it's going to go up to $75 per area code because inflation is getting us all. And so if you buy every area code in the United States, that would come to almost $21,000 for the year because you buy it as an annual subscription. And so what that does is that gets you what's called a subscription access number, or a SAN. And that gives you the right to download that list and scrub against it. Or if you're using a vendor who can do that scrubbing for you, you give them your SAN, and then they can do that scrubbing under your subscription. It's actually illegal. A lot of people don't know this. It's actually illegal for vendors to scrub without essentially piggybacking. You're not supposed to piggyback off of one SAN for somebody else. You're supposed to at least know that the people you're scrubbing for have SANs. So I always recommend, if you do any telemarketing, get your SAN for the area codes that you're going to be calling. Now, you mentioned states. There are a number of states that have their own telemarketing do not call lists like the federal list. In fact, I believe it's 12. It might be 13. I'm pretty sure it's 12. And those, they each have different ways you subscribe. Some you have to fill out paper applications and send in. Some you can go on websites and send in. Some you can pull the list down by an API. Some they mail you CDs. It's all over the place when it comes to the state lists. But there are a dozen states that have their own list. So being sure that you are doing that scrubbing, or you're working with a vendor that can do that scrubbing for you, and that you've got the right subscriptions so that that scrubbing can occur, is very important. And secondly, understanding your exemptions. So being able to keep track, if you want to rely on the transactional EBR, for example, being able to know when that last transaction was and calculate from there. Or for the inquiry, knowing when that last inquiry was and calculate from there. If you're relying on consent, knowing that you've got the documentation of consent and calculate from there. So I know it can sound like a lot, but it's one of those things where once you set up your procedures, it kind of runs itself. You just kind of have to get that through that first setup phase. Mm-hmm. The other thing I'll just mention real quick is some states do have different EBR calculations. So you heard me mention 90 days for the inquiry or 18 months for transactional. There are some states that have narrower windows than that. So you have to be aware and cognizant of those too.
Well, one thing to add on the Volie side of things for all of you is Volie does allow you to add your SANS numbers. So make sure to reach out to your rep if you have any questions on getting that stuff set up. And any further questions there. Josh, are there any calls that can be made without checking the DNC list? Or should you always make it a practice to check?
So if you're making telemarketing calls, then I definitely think you need to check the list unless one of the exemptions applies. Where sometimes people get in trouble is they don't understand really what it means to make a telemarketing call. So the telemarketing sales rule, for example, defines telemarketing as any plan or program to essentially market or sell a good or service. The TCPA uses kind of similar language, that it includes the commercial advertisement, right, of a good or service. And so things that you may not think are telemarketing can be. For example, let's say you think that a car is coming up for an oil change that's likely going to be due. And you want to call and tell the consumer, hey, we think you're about due for an oil change. Come on in, we'll give you $10 off. That's a telemarketing call. You're advertising that you can do that oil change. You're in that scenario, you're also giving them a discount, right? So you're really advertising the commercial availability of a good or service. That's different, though, from non-telemarketing calls. And so you don't have to check the DNC if you're making a non-telemarketing call. So let's take that oil change scenario and let's tweak it a little bit and say that the consumer has already scheduled an oil change. And now you're calling or texting them to remind them, hey, it's coming up Monday at 2 p.m. And that's essentially all you say, right? Is we're just reminding you, you've got your oil change scheduled for Monday at 2 p.m. Look forward to seeing you. That's not a telemarketing call. They've already committed to the good or service, essentially, right? They've scheduled it. You're not promoting any additional goods or services in that communication. You're just reminding them that they need to come in. Another common non-telemarketing call are customer satisfaction surveys, right? So calling to find out, did a consumer have a good experience at their last visit? Employment recruiting is also not going to be telemarketing. You're reaching out to say, hey, we'd love to hire some people. I know in this economy, it's tough. So those types of non-telemarketing calls don't have to be scrubbed against the do not call list.
Just to clarify, though, if you have an established business relationship in most states, can you make that oil change call within 18 months?
So in most states, let's say you sold them a car January 1, then you would have 18 months from January 1 that you could rely on the transactional EBR under federal law and under most state law. So you wouldn't have to scrub them out on the basis of their number being on the do not call registry. Now, I should clarify, those EBRs can be voided, right? So if the customer says, do not call me anymore, or asked to be put on your do not call list, that voids that EBR. And so they have to stay on your do not call list, your internal company do not call list, until they give you written consent. Because only written consent can override a prior request to be put on your internal do not call list.
And something that's good for all of you folks is that we do manage opt-outs within Volie. So we kind of can help you out there too. Josh, something you mentioned before, one of the pillars of TCPA compliance, you said, was pre-recorded calls. How does that relate to voicemail?
So I think there's two different types of voicemail, right? There's the voicemail where you've got a live agent who's on a call, gets an answering machine, and dictates a voicemail into that voicemail box live. That's not a pre-record. But if you've got a situation where you've got a pre-recorded voicemail that you're then dropping into that voicemail box, that is going to be a pre-recorded message. And I will tell you that the rules around pre-records are pretty complicated, and they vary significantly from state to state. So trying to draw broad brushstrokes on those is a bit tricky during something like a webinar. And it's definitely an area where if you're going to use pre-records, you'd want to work with counsel to make sure that you do what you need to do. But just at a high level, there are consent rules around pre-records. There's no such thing as an EBR for pre-records in established business relationships. So consent is really key for pre-records. There are typically disclosure requirements within pre-records as well. And some states have rules around like when you have to disconnect the line. Sometimes the pre-record has to be preceded by a live person. That it really varies from state to state as to what the rules are.
Mm-hmm. Well, let's go ahead and move on from telephone. And just to say one more time, we will not be taking live questions today due to the nature of the topic. But if you do have any questions, you can email us, or Josh will provide his information after the call, and can certainly help you out there after the call. But let's go ahead and move along to email compliance. Is there what do people need to know with email compliance? Can you talk a little bit about CAN-SPAM laws?
Yeah, so email, thankfully, is a lot easier. In the United States, email is regulated under the CAN-SPAM law, which is going on 20 years old at this point. And that law sets out a few rules for email. And it divides email into three categories. There are commercial emails, which are what we think of as advertisements, emails that are trying to market something. Then there are transactional and relationship emails. So that's like, say, you're reminding someone that a payment is due on something, or you want to let them know that their vehicle is ready for pickup, or something like that. That's a transactional relationship message. And then there's other, which is the catch-all for anything that doesn't fit into one of the prior two. And commercial messages are the ones that are most highly regulated, but even then it's a pretty light touch regulation. So for commercial messages, you need to have accurate information in the header. So your to, your from, your friendly from, that email header information needs to be accurate. You need to have an accurate and non-deceptive subject line. Then you need to, in the message, identify it as an advertisement. So you'll see that a lot of times in commercial emails, they'll have a little note at the bottom that says, this is an ad, or they'll just have the word advertisement, or so, right? So there's plenty of ways to do that. If the message itself is obviously an advertisement, you don't technically have to put any sort of disclosure like that on it. But it's another word. Who cares? It's a light lift. You need to include an actual mailing address and an unsubscribed system. And so that's why on most commercial emails that you get, right, there's an unsubscribe button. And there are some rules around how that has to work. You can also have a return email that is identified that the person can send an email to, and that will be their opt-out. So the thing with email in the US is it's an opt-out based system. It's not an opt-in system. And so, you can send those messages, and then when a consumer opts out, then you need to honor that opt-out going forward. For transactional relationship messages, it's essentially the first part of what I was talking about, which is the accurate header information and an accurate non-deceptive subject line. But I'll tell you, if you do email, there's a great thing on the FTC website called Complying with CAN-SPAM. If you just Google Complying with CAN-SPAM FTC, you'll find it. It's a great resource guide, and it's lays it out in a very easy to follow way.
Mm-hmm. And Volie also has a lot of tools laid out to help you be in compliance with what you need as well. Josh, one of the things you were talking about earlier was the difference between written consent and express written consent and established business relationship. We've noticed some states are kind of changing their laws with regard to established written consent. Can you talk a little bit about that?
Yeah, so I mentioned the Facebook v. Duguay case, and that case made it harder to bring claims under the TCPA because it narrowed the definition of an ATDS. In response, we are seeing state legislatures now passing laws or trying to pass laws that put into state law more restrictive telemarketing laws than what were there previously. And so for those frameworks, one of the common exemptions is, I'm going to back up here a second. So what you see sometimes with the state laws is they take a broader view of what it means to be an auto dialer. And so if you want to use a system that's an auto dialer, maybe under that broader scope, then it's good to have the prior express written consent. The good thing is prior express written consent in these new state frameworks that are coming up or are being proposed generally mirrors the federal prior express written consent rule. And so under the federal prior express written consent rule, what it is you have to give a disclosure to the consumer in a clear and conspicuous way that identifies who you are, that you're going to be making marketing calls or texts to them, or pre-recorded messages if that's the case, that you're going to use an auto dialer. It has to identify the phone number for which they're giving consent, explain that their consent is not required as a consent of purchase, and they need to sign it. So whether that's a written signature or an electronic signature doesn't matter, but they have to sign that disclosure. And so it's very important with prior express written consent that it checks all the necessary boxes, because if it fails on any of the magic language, then that consent is invalid. And that consent is very valuable because it's almost like a get out of jail free card. If you have that prior express written consent, you don't have to worry about established business relationship, because you can rely on that prior express written consent as your exception to the do not call registry scrubbing. You can rely on that consent to use the auto dialer. You can rely on that consent to use pre-recorded messages. It's your golden ticket. And so there is a lot of value to setting up a process or a procedure to collect that consent and track it.
But most states don't have these procedures now. Would you invest in this now, or wait until it becomes something that does impact you?
So I would, well, you're talking to a lawyer. We're, usually the most risk-averse people on the planet. My view is, you don't know when your state or a state that you're trying to call into may make a change to their law. So if you've already got a process in place to be collecting the consent, then you've got a trove of data that is already good and consented. So when that change happens, you're ready to go, instead of scrambling and having multi-layered compliance protocols for people who gave consent and people who didn't give consent, and right. And so I always tell people, get the consent. It's not, once again, like I said earlier, once you set up the process, it kind of runs itself. So it's just about getting it set up in the first place.
Mm-hmm. And speaking of that, Volie wants to help you gather that express written consent, and an exciting announcement here. We are starting work on a new mobile app. It's a huge long-term project. And one of the things that the app will help you to do is help you to gather those. But it's a huge long-term project. We'll have more to share in the future. We aim to be launching in Q2 of next year, of 2023. But we will have more to share as we get a little closer there. Just to take a little break from all this, it's a lot of heavy topics. I'm going to invite Liza from our team to jump in here and walk us through something neat within the Volie platform, and then we will dive back in with Josh for one last topic here. So Liza jumping in here. Liza, are you there? There she is. What do you have for us today, Liza?
I am going to share my screen. I think, can you add that permission just so I can share my screen quick?
Oh, I never remember.
I just wanted to jump on quick and talk through something that hopefully most of our accounts are like, oh yeah, we've seen that 100 times. We know about that. But if you don't, or if, just a lot of other things have come into focus, and maybe, you know, you've forgotten that this is there. I think this is something that's come up a couple of times recently, and really valuable, really helpful for your reps. So for the users who are actually logging into the communication center. The ability to customize their screen. So pulling forward the pieces that are important to them and hiding things that get in the way and maybe they don't really care about. It's more than they need to see. So at any point when a rep is not on the phone, whether that's when they're in queue selection or right now I'm in between phone calls, I can use this left-hand menu and click on this cog icon, the settings icon, and it'll open up my individual preferences. So this is not across the account. This is specific just to me as a user. There's a couple of things that I can toggle here. So the first two, incoming and outgoing message audio, that's specific to SMS messages. So those are the sounds that you hear when a message is sent or when a message is received. If you are a rep who lives in the SMS messages and those sounds drive you crazy, good news, you can turn them off just by unchecking those boxes. Those sounds go away. If you really like them, you should leave them enabled. First line down, default left tab in the communication center. So this is referring to this far left-hand column. You can pick which tab or which layer is defaulted on top. So there's three options there. There's contact info, prospects, or submit disposition. Typically, I leave mine on contact info, but if you are someone who does lots of work on sales leads, you might prefer seeing prospects on top. That might be your most frequently used tab. You can switch it to prospects or submit disposition if that makes the most sense to you. Second one down, same option, same question, but for that middle column, you can select which of those tabs opens up on default. If you first log into Volie and you've not changed any of your settings, yours would be set to vehicles. That's just the standard default. I switch mine to communication history so that I can see the most recent calls, emails, and texts that were sent to that customer, the rep who made those communications, and any notes that they left. Couple of other good ones though, contacts tab, that has all of your transfers. Maybe if you're transferring calls back to different departments in the dealership, contacts is a really good one for that. Otherwise, maybe if you are calling on customers who've serviced their vehicle, maybe having their most recent services on top is good for you. So you can kind of pick which ones make the most sense, and that one would be served on top. Last one, which I think is underutilized, is hidden tabs. If there are things in the communication center that you never ever use, you can hide them so that there's not so much to filter through or scroll through when you're using your communication center. So one that I talk with my accounts about, if you are primarily service and you don't work any new leads, you can hide that promotions. You can hide the prospects tab so that you're not seeing that tab with all of the leads in there. You know, another one, maybe if you don't use any external links, it doesn't need to be there if you're not using it. So you could select those tabs that you want to hide. Remember to save your preferences. Then when you go back into the call screen, those tabs are hidden for you. So it kind of minimizes that list that you're working from. If you're a manager and you work really closely with your reps, I would go through those options, kind of pick the settings that make the most sense for your team. And I would go around and I would help each person change those settings so that you know that they're working in the most efficient way that they can. So if you have any questions on those options or what any of those tabs mean, please connect with your rep. I think that's an easy one and it makes a difference for your team that are actually making these communications. So definitely worthwhile. There you go.
Thanks, Liza. Appreciate you hopping on here. Now, let me. Okay, we should be good to keep going here, Josh. So this isn't strictly Volley related or anything like that, but is there anything heading down the way in regards to new privacy laws that the folks here should be aware of?
Yeah, there definitely is. So in 2023, we have 5 new state privacy laws coming into effect in California, Colorado, Connecticut, Utah, and Virginia. And each of these laws has certain size thresholds for whether or not they'll apply to a business, but they are comprehensive privacy laws. If people are recall, the CCPA that came out of California in 2020 is currently in effect. That requires a lot of disclosures to consumers and gives consumers rights to access their personal information, requests that it be deleted or to opt out of the sale of it. These laws take that framework and grow it. So consumers will have robust disclosure rights. There will be additional consumer rights they'll vary a bit from state to state, but include the opt-out of sharing for targeted advertising, restricting the use of sensitive personal information, the right to correct their personal information, and the right to appeal any denial of any of the other rights. They also impose record-keeping requirements, data minimization requirements, cybersecurity audits, risk assessments, a whole host of privacy requirements on businesses. And it's important to keep these in mind because they are not rules without teeth. They carry significant penalties. The California one, for example, you can have civil penalties up to $7,500 per violation. And so if you've got, say, you're collecting information from visitors to your website in a non-compliant way, and you get 10,000 visitors a week to your website, multiply that by $7,500 and multiply that by a few months, and you've got some real money, right? So definitely something that the businesses need to keep an eye on. We are seeing additional legislation proposed at the federal level, although it hasn't passed yet. And we fully expect that more states will pass privacy laws next year. So privacy is here. It is here to stay. And I think the business world has got to get in line with it because it's what consumers want. And it certainly is what regulators are paying attention to now.
Certainly paying attention to, and it's one of those things where, it's not necessarily a dealer's fault, but it is their problem to learn how to stay ahead of things. What initial steps should any business take to stay ahead of it?
Well, so I think first is working with counsel to figure out which rules apply to your business, right? Because like I mentioned, that those new laws have size thresholds. There are some older existing laws that don't have size thresholds, but may have other triggers. And so knowing exactly which ones apply is going to be key. Then secondly is implementing what I refer to as privacy by design. So actually making privacy, and let me just clarify, I didn't invent that phrase. I definitely borrow it from all the privacy practitioners out in the world, but
I would have given you all the credit for what it's worth.
Yeah, well, and not deserved, but really thinking about consumer privacy a part of the conversations that you have around setting up systems, setting up processes, how you build your website, how you implement IT infrastructure, right? Making sure that a discussion about consumer privacy is part of that, and working with counsel who you can have those conversations with. And thirdly, be aware and be sensitive to the shifts that are happening. Not just in the regulatory world, but in the world of Apple, the world of Google, right? We know that the Google plans to deprecate third-party cookies in Chrome. I think it was originally supposed to have been this year, and then it got pushed to 2023. I think it might be early 2024 now, but that's coming down the line. Apple with its app tracking transparency feature and other tools that they put in place to enhance consumer privacy has an impact on businesses that do online marketing. And so just staying up with the trends of what's going on with regard to privacy, not just legally, but also in industry.
Well, really appreciate you taking the time, and definitely, I think that's the end of the scope of what we're going to get into today. But if any of you have any additional questions for our, me and my team here at Volie, or Josh and his team, Josh, well, you can always reach out to us. But Josh, what is a good place for a good way for people to get in touch with you?
Yeah, so check out our website, mslawgroup.com. We have a ton of resources on there, blogs, webinars, so on and so forth. My full contact information is on there. You can also reach out to me by email at jstevens, STEVENS, at mslawgroup.com, or call our office, 614-939-9955.
And we'll include that in the notes there on YouTube as well, if you didn't catch that. So, Josh, really appreciate the time that you gave us today to go over these important topics. We have another excellent show lined up next month for all of you on the Volie Session. We're going to be having Sarah Hoagie on here to go over tips and tricks with BDC recruiting, and how you can ensure to work to keep it staffed. So very excited for that one. Really appreciate the time with all of you today. And have a great day.